The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This morning, we are here in the matter of 4 different cases. The first one is State of Iowa versus Hannah Kilby. The second one is State of Iowa versus Jasmine Warren. The third case is State of Iowa versus Patrick Barrett, Jr. All 3 of those will have oral arguments accompanying them. The fourth one is submitted without oral argument, Iowa Supreme Court Attorney Disciplinary Board versus Scott Reinhart.
Thank you, Chief Justice. May it please the court. Counsel. The appellant, Hannah Kilby, is here today asking the court to require the state to do its job. That is, to require the state to prove their case with facts that are relevant, that are admissible, and above all, are constitutionally permissible evidence that bears upon the elements of the offense of operating while intoxicated. The state today is asking the court to uphold Iowa Code Section 321J.16 as applied to Ms. Kilby. Essentially, the state wants the court to uphold the statute to provide the state a shortcut to obtaining convictions on OWIs by being able to argue that because a person refused to submit to a blood alcohol test, that they must be guilty. This argument, line of argument, is something that the state is forbidden from doing in almost every other context involving the invocation of a fundamental right. The U.S. Supreme Court has said to punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort. We are simply asking the court today to find that absent a warrant or a valid exception to the warrant requirement under Article 1, Section 8 of the Iowa Constitution, that the state is not allowed to rely upon a person's valid exercise of their right to be free from unreasonable searches and seizures against them at trial, and instead require the state to do its job and prove its case beyond a reasonable doubt with facts that bear upon the elements of the offense. I believe it's important to note that there are 2 separate components of an OWI investigation. First is the criminal process and the resulting penalties, fines, mandatory jail time, and other consequences. And the other part is the administrative license revocation procedure with the Department of Transportation. The administrative part, the implied consent part, is based upon the premise that a person, in exchange for driving on the roadways, is impliedly agreeing to submit to a breath test in order for that privilege to apply. If the person is suspected of operating while intoxicated, they're requested to do a test. If they fail the test, their license is suspended for a period of time. If they refuse the test, the license revocation is doubled. We are not making any challenge whatsoever to the administrative procedure in this case. The administrative revocation, there is no challenge to that in Ms. Kilby's case. Ms. Kilby has already been revoked, and we make no challenge to that here today. The issue in this case is whether the state violates Ms. Kilby's due process rights at trial under Article 1, Section 9 of the Iowa Constitution by holding her valid exercise of a constitutional right to refuse to submit to a search against her at trial. In this case, the state had no warrant and has proved no exception to the warrant requirement under Article 1, Section 8, which could compel Ms. Kilby to submit to a search of her person, which in this case was the breath test.
Mr. Gangestad, how would you distinguish our State versus Benson case? And in that case, the defendant was charged with OWI, refused to submit to a blood test, and the question presented was whether proof of refusal violated due process. And we say, does the due process clause render the testimony of the sheriff inadmissible? We answer no.
Your Honor, was that case prior to the Birchfield case?
It was.
Okay. In Birchfield, there was a shift of framework under the Fourth Amendment. The court looked at the search under the search incident to arrest exception in Birchfield. Under the search incident to arrest exception in Birchfield, the court found that there was different privacy interests in blood and in breath. And the court found that the search incident to arrest exception did not apply to compel a blood test, but they found that it could apply under the Fourth Amendment to compel a breath test. We went a different direction under the Article 1, Section 8 of the Iowa Constitution in Pettyjohn. In Pettyjohn, the court stated that there was no categorical exception under the search incident to arrest exception to allow or permit warrantless testing of a person's breath in this situation. And it's a major difference. The court found under the Iowa Constitution that the search incident to arrest exception does not categorically allow a breath test to be compelled from a person. Therefore, the state does not have the ability in this situation to compel a breath test. If they cannot compel a breath test, which is a search, a person has the absolute right to withhold their consent to that search.
In Pettyjohn, though, didn't the concurrence by Chief Justice Cady say that driving is different than boating?
Yes, it is, I think, for certain purposes. I think what he was referring to mostly was the implied consent procedure as it relates to consent. And in that case, the boating procedure had an additional penalty that was attached to a refusal of a test.
It was $500, right?
Correct. For a first refusal, $1,000 for a second, and $2,000 for a third.
And for driving, isn't it $200? Isn't there a similar penalty?
That's a reinstatement fee. So there is no automatic penalty for refusing a test. Here, I think what we have to look at is this actual search itself. The search in both of the...
Counsel, can I interrupt you there, though? But there was no search here because she refused, and they honored that refusal. Is that correct?
That's correct. There was no search here. The issue is the fact that she did have a right to refuse, a right to withhold her consent, so therefore she did have the right to exercise her right not to be searched. This is the ability...
And that was honored. She was allowed to exercise that right. The only distinction is that the statute then says that when she exercises that right, then just the fact of refusal is evidence that can be presented at trial, but nothing more than the fact of refusal.
Correct. And I think that's when we go to the fact that she did exercise a fundamental right, and the fact that they can use that against her implicates our strict scrutiny analysis. That she did have that fundamental right to refuse, and this, the ability of the state to comment on that is a burden upon that exercise of that right. And that's where we move on to the strict scrutiny analysis to determine whether or not the state has offered a compelling state interest and that it is narrowly tailored to support that state interest. Here, the state's argument supplies no facts that this court can rely upon that there is a compelling state interest. In fact, I don't believe that...
Counsel, couldn't it be true that she may have had a right to refuse, but at the same time, an adverse inference still would not be unconstitutional? I know, at least as I've read our due process cases on this, for example, the courts held pre-Griffin that it doesn't violate the Iowa Constitution to make an adverse inference from trial silence. The Benson case says it's okay to make an adverse inference from the refusal to submit to a blood test. So within the Iowa precedent and the Iowa claim, can't both of those things be true?
I think that if the court engages in an analysis of whether or not those rights can be burdened, then it is possible that a constitutional right can be burdened. However, we don't believe that it meets that high threshold in this case. The statute is not, it does not meet that high standard because it applies in all cases and in all circumstances. The statute simply states that 321J16 allows a person's refusal to be used in any criminal or civil action. It doesn't make any exceptions. And I would give you one example. Say a situation where evidence of flight is admissible. The court still examines if there's a nexus between the flight and the illegal conduct claimed. Here, we're not even looking at a nexus. We've got a categorical rule that says this is going to be admitted against the person. Basically, there's little probative value in that. It's admitted against someone who is drunk or sober, and I don't think that the refusal actually informs the jury about what they should be looking at. Under the influence is what they're looking at, is the person under the influence of alcohol, and that has a specialized meaning under Iowa law. Has the person's reason or mental ability been affected? Have their emotions been visibly excited? Has their judgment been impaired? And I don't think that a person's refusal to submit to a test that they're not constitutionally required to submit to informs the jury of those elements of the offense.
I mean, essentially, if we accept your argument, where we are left is law enforcement will have to get a warrant for a breath test of a driver. Is that correct?
Not necessarily.
When would they not need to?
When it's validly consented to. There are many, many cases where a person will submit to a chemical test. And I think part of the...
So you're saying that the terms of the consent are not coercive?
That's not before the court in this case, whether or not
I mean, it strikes me it's all wrapped up as one thing, isn't it? I mean, there's either a Fourth Amendment issue or there isn't one, or not Fourth Amendment, Article 1, Section 8 issue, or there isn't, right?
Well, I think they're all under the same framework. Consent, obviously, and if you validly consent, that is one exception to the warrant requirement. Another one would be exigent circumstances, if the state were to prove exigent circumstances, or a warrant. And I do believe that there are circumstances where a person can validly consent and knowingly and voluntarily consent to a test. The issue is not before this court of whether or not the implied consent procedure is coercive in and of itself and makes...
Yeah, but don't we have to think about that intelligently in order to decide this case, right?
Again, there's not any challenge to that in this case. The precedent under Iowa law is that the consent based upon the implied consent procedure has been upheld. I think that the difference here in this case is that Petty John has shifted the framework with regard to the search incident to arrest exception.
Yeah, except that...
Well,
Go ahead.
in Pettijohn, there was a factual case-by-case analysis of whether consent was there. And so therefore, there's not a categorical rule of consent. It depends on the totality of circumstances. At least that was what was applied in Pettijohn. And we kind of reserved this Johnson v. Zerps issue, which is whether you have to meet a higher waiver requirement. But in Pettijohn, there's 3 or 4 pages going through the facts of the case, suggesting there might have been consent. And in Pettijohn, the court ultimately came to the conclusion that the consent based on the specific facts was not there. Now, that could have turned out under a different fact situation differently. And the same is true with respect to exigent circumstances, of course. That's a fact-based exception. And so in order to invoke consent or exigent circumstances, the state is required to make a fact-based record. Is there anything in the record to support that?
I don't believe so. Obviously there was no consent here, so we can't talk about whether or not she validly consented to the test. The state has offered in the record no evidence that there was any exigency outside the normal dissipation of alcohol in somebody's blood. And the court in McNeely, our Iowa Supreme Court in Lovig and in Johnson have all concluded that the simple dissipation of alcohol in somebody's breath, blood, or urine.
But I mean, let's kind of, I don't think that we can compartmentalize things that neatly. You're saying that the demand that was made on her was to undergo a search that would have been unconstitutional if is that correct? If she didn't consent to it.
If the state can't prove an exception, then she has the right to refuse the search.
Right. And Pettijohn, I mean, I don't know about this case-by-case stuff, but what we said, you won the case, so you know it well, right?
Correct.
What we said is that the $500 was inherently coercive.
As to consent.
As to
correct.
consent. So all boating, from boating from now on, unless there's exigent circumstances, you had to get a warrant. Isn't your case leading down the same path as to driving now?
I see that I'm out of time. I answer the question.
Yes, you may.
I think that the state, while yes, there may be certain situations where it is inconvenient for law enforcement to do so, that is what the Constitution requires. We have to have an exception or a warrant. And if we don't have one, and in the Riley versus California case, the U.S. Supreme Court stated that the warrant requirement is not merely an inconvenience to somehow be weighed against the claims of police efficiency. The reality is that we do have other evidence that can be used to convict people of operating while intoxicated. And as I said, in fact, a lot of times people will submit to a breath test. There are observations, witness observations, driving observations of erratic driving. There are physical observations of slurred speech, odors of alcohol, field sobriety testing, the officer's training and experience, the body cameras, in-car cameras, in-toxilizer room cameras. All of those things bear upon the facts which a jury actually must determine the person's guilt or innocence. And that's what we're asking the state to be forced to rely upon, is evidence that actually proves that this person is guilty. I see that I'm out of time. Thank you.
Thank you, Mr. Gangestad. Ms. Hines?
May it please the court, counsel. It's important to keep focus on the precise issue.
Can you press your button, and then Justice Appel can try again a test?
Yes. It's important to keep focus on what the precise issue in this appeal is and not get swept away in the discussion about whether Pettijohn extends to implied consent under Chapter 321J. The question here is specifically whether the admission of the evidence of Kilby's refusal to take the test, which is permitted by statute, is a burden on her exercise to a constitutional right to be free.
And I'm going to have the same message for you I had for Mr. Gangestad. I don't think you can compartmentalize it. I joined Thomas on the Court of Appeals. That was one of the first opinions that I participated in. I think it's correct. I think if there is a Fourth Amendment issue with if a search would not have been valid under the Fourth Amendment or under Article 1, Section 8, you can't admit the refusal to agree to it as evidence against the defendant. I think that's a problem, isn't it?
Well, in terms of compartmentalizing, I'd like to just focus on the breath test as opposed to a search of property in this case. And in Thomas, there was no constitutional burden found upon the admission of refusal evidence. And that's what the focus of the state's contention is that what the true argument is whether there's some burden on Kilby's Article 1, Section 8 right to be free of unreasonable searches that is violated by the admission of her refusal to consent. And the fact that she did refuse to consent in this case is key because this is not a motion to suppress. It's a motion in limine to keep this certain evidence out. And it's easy to be washed away into the Pettijohn and consent and search incident to arrest, all that law. But I think it's more simple than that in this case. And that is just a question of whether her rights to be free of search and seizure was burdened by the admission of this evidence. We know that the admission of such evidence is not a violation of the Fifth Amendment, and the state heavily relies upon a commentator that discusses that the right impaired by the Fifth Amendment is a different, by the introduction of incriminatory refusal to incriminate oneself is different than the introduction of evidence of a search that was not taken. There was no, the purpose of the Search and Seizure Act is to protect privacy.
Well, let's take a look at commentators. Lefebvre has some commentary on this very issue, and it strikes me as spot on, but let me have you respond. Lefebvre basically says, well, if there was a lawful underlying basis for the proposed search, then you can comment on the evidence. So, under the Fourth Amendment, because Birchfield says categorically breath tests do not need a warrant, under the Fourth Amendment, you can comment. But Lefebvre goes on to say, when there was not a basis for the search, then you can't comment on it. And plugging Lefebvre into our case law, in Gaskins, we said we limited the scope of search incident to arrest. In Birchfield, the Supreme Court went in a different direction. They said you can always, pursuant to a search incident to arrest, do a breath test. We went in a different direction. If there is no underlying rationale for admission of the evidence, then under Lefebvre, you can't comment on it. Now, you've read Lefebvre too. Please go ahead and critique my analysis of it, and then respond, please.
Well, I think it's just a difference of opinion. I think that in this case in particular, there was no violation here of her rights under the Iowa Constitution or Fourth Amendment. There was no search undertaken. I don't think it matters as much whether the search was lawful if it's permissible to comment on the refusal, because the refusal evidence is it's not necessarily used to it's part of the guilt, but it's not a mandatory presumption, and the purpose of that is that they want to encourage people to take testing, but the reliability of the criminal process wants to would require that the jury be told about why the state does not have breath test evidence. The jury would wonder why there's nothing concrete in the test realm to prove DUI. So that's one of the reasons that the refusal is permissible. And I think that gets it away.
Ms. Hines, assuming she had the right to refuse the test and the request was not lawful, how would you square the state's position with Gibbs, kind of the penalty, or I guess the analysis that adverse inference instructions potentially might be penalty on an invocation of a right? How would you distinguish that, or how is it relevant to this case?
I would harken back to the commentator, which the Gibbs was a Fifth Amendment self-incrimination comment on that, and the adverse comment on that, and that is not permissible, period, because the First Amendment or the Fifth Amendment protects a person from being a witness against themselves.
But counsel, you have a statutory right to refuse the breath test, and wouldn't the Gibbs reasoning apply if it's a burden on the right to refuse if there's a penalty? I mean, I'm back to Justice Mansfield's point that these are really intertwined.
The, again, I think it goes to the purpose underlying the constitutional right we're talking about. I also would just pause to say I don't think, I'm going to kind of parse my words here, but I don't think there's a constitutional right to refuse to submit to testing, where there is a constitutional right to be free of unreasonable searches and seizures. So it's not a constitutional right we're discussing anyway, it's a statutory right.
But we said in Pettijohn that for a boater, there's a constitutional right to not to be free of warrantless testing, absent exigent circumstances.
To be free of warrantless testing, that doesn't create, that. Again, I'm parsing words, but I think that's basically a way of saying free to be, or free to be.
I guess I'm puzzled why both sides in this case are so averse to our just kind of deciding, does Pettijohn apply to driving or not? I mean, that's kind of what I thought
Okay.
was teed up by this case. And
Okay.
what's the state's position on
Well,
that?
that's what I can discuss Pettijohn. My main point in briefing and today is that this is not a case where we need to decide, where you need to decide whether Pettijohn.
Well, in fact, I mean, your position, I think, and you can correct me, is a broad one. I mean, your position is that when there is no test done, whenever there's no test done, you're free to comment in the criminal prosecution about the failure to take the test, period. I mean, that's the argument in your brief, I think. It's categorical and unqualified, and, you know, it's kind of simple. I mean, it's, you know, end of story. Am I mischaracterizing you?
No, that's the argument. And I would just add, because we're discussing Pettijohn, that the Justice Cady's special concurrence explains the reasons why the lack of consent in that case was not voluntary, but why it would be in implied consent driving cases. So
Counsel, was Pettijohn wrongly decided?
the state believes that it is, yes.
What would be the impact on the ability of law enforcement to detect and enforce our drunk driving laws if test refusal evidence was inadmissible?
I think it would, first of all, it would create more situations where the evidence is that the state has will be confusing to the jury because they won't know why there's no test results in evidence. Second of all, I think it's a way of preventing kind of the battle of trying to obtain evidence. The implied consent gives a person a choice, and the choice for refusal, or when you select refusal, that is part of the consequence of the refusal, and that is allowable. So that encourages testing, but it also explains, I mean, it encourages testing by exacting a consequence for the refusal, but it also explains in terms of trial why the state has not presented evidence of intoxication in terms of a breath result.
Can you point to me to someplace? Oh, I'm sorry. You want to go ahead?
Just my question is there harmless error when the district court mentioned the test refusal?
I'm glad you asked that, Justice Waterman. This is a harmless error case, and that's another reason I don't think that this court needs to actually go back and apply Pettijohn. In this case, the state listed in its brief what the district court, all the evidence the district court found. It did mention the test refusal, but without the test refusal, there would have still been more than ample evidence to prove Ms. Kilby was driving while intoxicated. So any error in the admission of the refusal evidence was absolutely harmless, beyond a reasonable doubt.
I may have missed something, but I saw nothing in your brief that argued that Pettijohn was wrongly decided. Am I
And
wrong?
that's not the basis of my argument today. I was asked a question about it, and that is the state's position.
Sure.
But we are not arguing Pettijohn in terms of its holding as it relates to boating.
Right.
If it is correct that we need to address the underlying search and seizure issue to resolve the question presented here, and Pettijohn is on the books, how would the state distinguish Pettijohn in light of the dissent in that case that says there is no constitutional distinction between boating and driving?
Well, the state would accept that argument, and it also would point to, as I said, the argument of Chief Justice Cady in concurrence, and distinguish the fact that the implied consent in driving is not a coercive consent because of there are no penalties other than license revocation, which is a civil penalty, in terms of encouraging that consent. So the coerciveness under Pettijohn is just not present under 321J6.
Counsel, does the Supreme Court's analysis in Birchfield apply equally here?
Yes, I think it does, in terms of, well, it doesn't, it does, I understand that Birchfield's under the Fourth Amendment, and this is a very particular argument.
Other than the different constitutions that we're dealing with, is the analysis identical? Or is there any difference that we should know about?
I think that Birchfield is applicable here, and I can't, other than the fact that this is under a challenge under the Iowa Constitution, I don't think there should be.
Except under the Iowa Constitution in Gaskins, we limited the search incident to arrest exception to the exclusionary rule, and that was applied in Birchfield in a categorical way, and we rejected that in Gaskins.
I think the difference in Gaskins is that was not a search incident to arrest, the evidence saw it was not of the person. It was, this is a kind of evidence that the state is allowed to search for when a person's body is detained and arrested, whereas the Gaskins.
Well, but in Gaskins, we clearly said that the search incident to arrest exception to the exclusionary rule is not a categorical one. It doesn't apply in all cases. And we said that evidence gathering is not within the scope of the exception. The Supreme Court of the United States went exactly in the other direction in Birchfield. They're surely entitled to do so. Mm-hmm. But we have a significantly different approach under the Iowa Constitution to search incident to arrest as compared to the categorical approach that was used in Birchfield for breath.
I don't disagree with that statement. I would push back a little bit on the fact that I do think the request for a breath test is different than the search that was extended in Gaskins.
But it is a search, I take it.
It is a search, yes, but I think it is of different kind, and that makes a difference in this case. Well, in this case, or in any case in terms of implied consent, but.
You may wrap up.
I'm sorry. The state requests this court affirm the district court's ruling denying the defendant's motion in limine to exclude evidence that she refused a breath test. Thank you.
Thank you. Mr. Gangestad?
Could you begin by addressing whether this is a harmless error case?
Yes, Justice Waterman. I first would like to point the court to State versus Moorhead. And in Moorhead, the court stated that reversal is required if the rights of the person are injuriously affected. And here, if the court is going to accept my argument that the defendant did have a constitutional right and that was harmed by the introduction of the refusal, then prejudice is presumed. As to the state's point, that there is plenty of evidence here to convict, I would again point the state to Moorhead, where the court reversed when the defendant said he was, quote, drunk as hell, and bizarrely exclaimed that he wished he had a glass eye. Pretty strong evidence of intoxication that the person exclaimed themselves that they were drunk as hell. However, the court overturned that and stated that it was not harmless error. So I believe that, and the other issue is that the court specifically relied upon the refusal of both the preliminary breath test and the data master test in this case, and stated that based upon all of these findings, I find the defendant guilty beyond a reasonable doubt. I don't think you can extricate that specific finding. And I think, that was part of, a very large part of the court's ruling in determining this issue and preparing that case for appeal. I want to shift.
Do we need conditions?
Justice Mansfield, I'm glad you brought that point up. I'm part of the Iowa Association for Justice, and we have submitted some comments on the proposed rules. I was part of that group that submitted those comments, and that would be something that we would very much like to see happen under the Iowa rules of Iowa court rules. I do want to quickly address the state's position that even if there was a constitutional right, she wasn't searched. So you can comment on it. Well, doesn't that absolutely make the right meaningless? If a person has the right to...
Counsel, and related to that then, in Birchfield, the U.S. Supreme Court said that a blood test would violate the Fourth Amendment if it was required, but it made a distinction then, so recognizing that blood tests under the Fourth Amendment would violate the Fourth Amendment, but still made a distinction between, it said it's one thing to approve implied consent laws that impose civil penalties and evidentiary consequences, but quite another to impose criminal penalties. So why does that analysis not apply under the Iowa Constitution?
So I think that the court should look at the context under which that was stated. The court was referring to Neville, and in Neville, they were comparing the right to, say, refuse a breath test with the right to your Miranda rights, is what they were comparing it to. And they said Miranda is of a constitutional nature, and you can't comment on that. However, at the time, there was only a statutory or legislatively created right to refuse. You didn't have a constitutional right to refuse. So therefore, they said, that's fine. You can affix evidentiary consequences to that. But now I think under the Iowa Constitution, the right to refuse under these circumstances, not in all circumstances, but under the circumstances of this case, indicate that she did have the right to refuse. It was of a constitutional nature, and I do think that it is then violative of her rights to comment on that. I want to bring up an example because I think this is important. If we accept the state's argument that 321J16 should be upheld, let's put two people in this situation. One person, both of them are subjected for our purposes to a warrantless search, an unconstitutional search, or one that is not authorized by the Constitution. The first person is successful in asserting their rights, and there is no search that is obtained. The second one isn't successful. A search does uncover evidence of criminality. That second person then gets to go file a motion to suppress evidence, and if they're successful on that, the prosecutor can't talk about it at all. The first person who is successful in asserting their rights gets the prosecutor to comment on that at trial if we uphold 321J16. And I think that that's an absurd result when in both cases the search is a warrantless one and not authorized by the Constitution. I would also like to address here, I think the court brought up Gibbs, and I think that's a good analogy here. I think this also allows the jury to avoid having to actually look at the evidence. And the court in State versus Ness had a similar situation. In that case, the court we had a situation where a PBT result was admitted, and the court had to determine if that was harmless error. PBT results are inadmissible. The court said that a PBT result is of the kind of nature that the jury's going to rely upon it to, quote, avoid the messy business of actually determining guilt from the facts. And we have the same situation here.
You may wrap up.
Sure. The jury is instructed specifically that a refusal can be used against them. And that's exactly the kind of evidence that allows a jury to avoid the messy business of determining guilt from the facts. We're asking the court to find the constitutional right to withhold consent to search does exist under the holding of Pettyjohn in the OWI context when no warrant or exception applies. Find that under these circumstances, 321J16 does not satisfy strict scrutiny, and find that the refusal of the warrantless test violated Ms. Kilby's due process rights under the Iowa Constitution. Thank you.
Thank you. We will take a brief pause here to allow the changing of the guards here at the table. And then in a little bit, when the clerks are finished with that, the second case, State versus Warren, will commence.